All right, people, we are live. Okay, my apologies. I had to reboot the computer and do everything again. That is to say, reboot the computer. Okay, can you hear me now? Because I don't want to have technical difficulties like we had the last time with the audio. So I'm an old man, by the way. I didn't know what F meant in the comment section in terms of it meaning that my audio was out. So have you tried turning it on and off? Hey, Viva. Okay. Can we all hear me? I think we can hear me. Let's just see. Are we live yet? 2 minutes late. It is a new shameful record. Can we all hear me? We can hear me? Okay, good. We can hear me. Okay, Robert is not in yet, but he's always reliable, and I sent him the link this time, so I know that it's going to be good. We're going to talk about a few things tonight. Did I invite Barnes? I sent Barnes the invite, unlike the last time. If I look tired, by the way, it's only because I have been camping for 3 nights with 3 kids and a dog. And we left the paralyzed dog at home because cleaning up pee and poo on a hardwood floor is much easier than in a tent. And holy cows, we spent the first night, if anybody's interested, all 5 of us and the dog in one tent, and then the second night and third night we pitched the second tent to give a little more room. Barnes is in the house, and now I see his thumbnail, and it's making me feel bad I didn't put on a suit and tie, but it's still too hot in my basement. On the menu tonight, in terms of discussion, let's get this perfect. Look at these bags under my eyes. On the menu tonight, we're going to talk about Flynn because I have got some questions that I think Barnes is going to know. Robert is going to know the answer to. We're going to talk actually Carpe Donktum and the DMCA issue because I have some questions. I think Robert's going to be able to answer them. I think we're going to talk CHOP class action suit because Robert sent that to me about 3 hours ago and I read through it quickly. It gives you a good idea as to what's going on, but I think we're going to touch on that. And we're definitely going to have to touch on Legal Eagle suing for a FOIA request and the lawsuit. I don't know if Barnes has seen it yet. Robert, I'm going to stop saying Barnes. It's a bad habit. So that's it. Same rules as always. I'm going to do my best to get to all the Super Chat questions, try to keep them on topic. Like Super Chat, we appreciate all of them. But if they're too far off subject, we'll read them and thank you for the support. But it helps to try to keep things on topic so we can have a quasi-linear show. I just called it a show. That's a first. Jeremy Landry says, F comes from the video game Battlefield. The game had a touching screen where a soldier is laid to rest, and the game prompts the player to press F to pay respects. Well, that makes sense. Now, I knew that it meant, something bad. Okay. Let us do this. I shall bring in Robert. Oh, by the way, tweet this out and send it out because sometimes notifications are late. And I just realized this. We're going live at the same time as Matt Christensen. And I feel bad going live at the same time as other YouTubers who, I don't know, I guess operate in the same field, but I have great enough difficulty organizing my schedule with the kids and the wife. I can't even start thinking about organizing it with other YouTubers. Okay, let's do it. We're bringing in Robert. He's looking dapper tonight. How do I add to stream?
Yeah.
Robert.
Hello.
How you doing?
Good. Back in Vegas.
There's a bit of lag. Oh, you're back in Vegas?
Yep.
Okay, there's a substantial lag, so I'm going to go slowly to make sure that I don't overlap. You're back in Vegas. How is life back in Vegas?
Good. They're starting to put some restrictions back. They're talking about doing mandatory masks everywhere indoors and some places outdoors. But otherwise, it's quasi back.
Okay, and the casinos are all open for business. Hotels are open for business.
They are.
I would be happy to play some poker, but I'm not sure that the borders aren't open, so we can't get to Vegas for non-essential travel. Let's see. We got 2 super chats. Hi from Brisbane. Thanks for doing the live stream. Nice fish video. Gave me a good laugh. Yeah, I went fishing, Robert, with the kids, and we caught 5 catfish and I think it's a sea bream or something. Good times on the camping trip. And we got NFIB versus Sibylus government can compel purchases. Also, letters to Brutus is so hard to find, but good read. Okay. Robert, what do we want to start with? Do we start with the shortest possibly What would be the shortest? Do we start with Sullivan so we can get Sullivan out of the way and move into Carpe Donktum and Chop and maybe Legal?
I'm thinking I'll start off with credit to the people who put in comments to the last live feed, the last show, which it's always good. It not only feeds the algorithm, but I actually read through them, and because usually there's wide, the feedback's always interesting, and often there'll be some information or intel in there that will make me second guess my opinion and at least require I research it further and sometimes change my opinion. And there were some good comments on the Rayshard Brooks case. Two primary points that were of utility. One was that that what is true is that in the United States, police officers are trained to shoot to kill, not trained to shoot to maim. Now, there are police officers and military officials in other parts of the world that are trained, actually are given longer training. But it is true in the United States, your typical gun training, your typical police training, they tell you to shoot to the body mass, don't try to shoot something else. So that criticism of the police officer would be an unfair criticism given his training. So that was a good insightful comments that people had. The other was people recommended looking at all of the videos from the Rayshard Brooks case. And so I went back and looked at all the videos that are available. And if you look at all of the videos, it does look like the videos that the media has been highlighting and excerpting are the most incriminatory. Whereas if you look at the entire video sequence, they're much more like what will be shown to the jury, much more exculpatory because they show how quick things are happening. They show how violent the action is, and they show how quickly his shots are right after the attempted use of the taser against him. They said he deliberately dropped his taser, but it didn't look that way when you watch the whole video. It looked like the effect of the taser shot coming from Brooks caused him to drop the taser. He was trying to tase him before shooting him. And so he went to the gun when he thought it was the only means possible. And at that time, it strikes me that it would be difficult to believe that he knew that the taser no longer presented a danger. And of course, that there's the second clause that says that if you believe there's probable cause, he's just committed a violent crime, which he has. Then the question is whether or not you believe that there's a reasonable belief that he poses a risk to someone else. And there is evidence by what one officer is going back and forth to what appears to be their computer apparatus inside their police car, looking up information, and that would confirm what has been reported elsewhere, which is the officers knew his history. And his history is interesting. Snopes and other people try to be dismissive of it because what the nature of child abuse charges is that they're never detailed. You only get the charge for confidential reasons for the child. The information is sealed. So Snopes was like, oh, you can't prove that just because he was charged with crimes that sound like that are family battery and family battery violence and child endangerment and cruelty to children. That doesn't mean he necessarily did anything wrong to the children. Okay, that's not the most persuasive argument I've seen. And his history is he has a long criminal history going back to his teenage years, including armed robbery, including escape from police, including violence towards police, almost ran over a police officer. So the long extended history, if those police officers were aware of it, and there's reason to believe they were, would be that this guy is an extreme danger to others. So when you combine that with probable cause he just committed violent crime, they don't even have to prove the taser was a viable weapon at that juncture to have justifiable deadly force to use. So it's more evidence that case is a wrongfully prosecuted case. It also appears he definitely did not kick the guy. They took a still shot, the prosecutor did. If you take out the still shot, look at the video, he's trying to walk over him. And he's in sort of a hurry to try to get ER there. So none of that is consistent with a deliberate or intentional shooting. So I think given that evidence, I lean towards that they would likely acquit him anyway, but I would say now it's an 80-90% chance unless you get a bad jury.
And it's amazing. Nate Brody did another meticulous breakdown of that video, the scenario, what the DA had reported in the wake of the shooting. I mean, it seems that the judiciary system, policing, has become so politicized now that some of these decisions are being made for political, social reasons as opposed to justice reasons, which is the ultimate irony. I got a bunch of emails as well talking about tasers, and people were saying that although that taser has a two charge system, that it can still dispense an electrical charge either at close range or if the prongs are attached, it can continue to charge so long as the battery is charged. There's details in there that make it by no means cut and dry. But what the DA was saying in the public statements in the wake of the shooting don't make sense, and you question how they can be made.
Oh, exactly. I mean, I think they were false statements, period, by the prosecutor, and he's brought a bogus prosecution for politicized purposes, and we're seeing that in a lot of places across the country. It's interesting having local DAs be at war with their police. That raises some serious questions.
Yep. Now, and incidentally, Sakake Onsei says, what are the rules we can avoid these stupid mandatory mask? What are the ways we can avoid these stupid mandatory mask rules? Really need to shove some law into Government Kate Brown's face. Help us in Oregon. I mean, go.
I looked up a lot of it. There's actually a very good constitutional argument that there should be a constitutional right to how you express yourself through clothing. And if you establish that right, it's never been fully adjudicated by the courts, been hinted at in some anti-mask laws, statutes that have been challenged over the years, been hinted at in some school dress code cases, hinted at in terms of being able to wear certain things into court, but never established. But I read a legal opinion from the University of Maryland Law Review, which was really good, really argued that things like tattoos, all the different ways you express yourself through clothing are deeply personal, deeply expressive, deeply associational, often spiritual for people for religious purposes, and that we should just recognize in general a right to do so, and so that any law that restricts that should be based on what is strict scrutiny. So it should be narrowly tailored to a compelling public interest. And I think in that context, the mask laws could be challenged, but it would be an attempt to establish new constitutional protections. In the context of employers and businesses, they're probably protected because OSHA and others have been issuing this, and where the states have issued mandates, they're probably protected from suit. But there is an argument that a lot of people are missing in the business world that some of their corporate counsel are advising them of, which is a risk that they be sued under the ADA, Americans with Disabilities Act, because it does trigger the health issues with the mask are very much still in controversy. They're far from clarity because the size of the COVID particle is so small. There's some studies that say it clears that it will protect them, but most of those studies have been done in sort of abstract settings, not the real world. One study that came out in the real world said it didn't protect them, but then they retracted that study because they said they weren't sure what the impacts of the data were. I do know I'm getting a lot of people saying that it's causing them things like dizziness and other headaches. And I talked to a nurse, and a nurse was like, that shouldn't happen because if they know how to wear the mask correctly. But that's a practical problem. Are we going to train 330 million people overnight to know how to wear a mask properly so the complications don't occur, and that its potential protective benefits do accrue to the individual? I think that's impractical. And I researched more medical studies, and there are a good number of medical studies out there that say that carbon dioxide poisoning can happen in response to, depending on how the mask is worn, how long it is worn, the context in which it is worn. Talked to an old client out of the construction industry, and he said that wearing masks indoors for too long will cause problems. That was his experience. Now he's in the drywall business where particular problems can occur from wearing a mask. So his advice was that he didn't think it should be mandatory, it should be discretionary up to people because they don't know fully what they're getting into in mandating it so broad scale. But it is there's no court cases out there that have said the government cannot require a mask, or that an employer or business can't require it as a condition of service. What I can tell you is that if someone had, like, autistic kids have problems, some of them have problems with masks, people have health issues, have problems with masks. The way to handle it is, if you feel strongly about it, just say that for your health reasons, you can't wear a mask. And technically either the employer or the business can be at legal risk if they inquire as to what that is, because that gets into ADA issues. So so that's, I think, the potential legal angle, but I'm still researching it. What I can say to the folks listening is that right now there's no case law on this. So we're in uncharted territory. But in my view, there's good grounds to, at least theoretically, to challenge some of these mask mandates.
And here's actually a super chat on point. James White says, for a person who has damaged lungs from valley fever and have to exert more force breathing through a mask, is my Sharona Cyrus, my silly Cyrus, a decent excuse to avoid jury duty?
We're going to have a very interesting, I'm going to be in part of one of the first jury trials they conduct at the end of August in Pennsylvania, federal court. And it's going to be real interesting how they handle that. They're talking about trying to seat the jury voir dire and bring him in groups of 15. They're talking about how they're going to seat the jury. The jury may be seated. There may be like 3 people in the jury box, and then the rest the other 11, including the 2 alternates, sitting in the crowd. This would be really weird. I don't know how they're going to do this practically. They don't have any facilities to do this, really, because federally, and because the U.S. Supreme Court, of course, affirmed this recently for states, you got to have 12 jurors. So I'm very curious to see. There's a lot of skepticism in the legal community about how this is going to work. I think there's going to be a lot of people who are not comfortable sitting on the jury, and that will both the people who always want to get out of jury duty. I think now will be saying, my health, no. So there'll be some of that, and there'll be people with sincere concerns too. So I think it's going to be real tricky.
Amazing. I'm going to try to get through these super chats before we get into the first subject. First, Flynn is not yet free. Also, should Trump pardon Flynn even if they drop the charges so Obama can't come back on him? We'll get into that in a second. Actually, that'll be the first subject. I just want to try to get through some of these super chats before we get started. Lance Taylor, watched your videos for a while, but what do you think of this call for defunding the police, especially in larger cities? Any thought from Mr. Barnes? We talked about it in the last stream, actually, quite a bit. But we're probably going to get into it in this one because we're going to talk about CHOP, and that'll come back up. Acquitted for all charges or just for felony murder? Does the grand jury review all charges as a group? This would be in Rayshard.
Yeah, I think the other charges, I don't think he did kick him or anything else. So I think it's going to be straight acquittal. By the way, the felony charge in that case is insane. I went back and read the charge because I assumed that they were alleging the arrest was bogus, and that's why they could charge felony murder. Instead, they got the dumbest interpretation of felony murder I've ever seen, which is if you attempt to commit murder and the murder happens, it's now felony murder, which that's never been felony murder. Felony murder, you're committing a separate felony and someone dies in the middle of it. They're trying to claim, they assaulted him with a deadly weapon, by which means they killed him. That's a joke. That's not a legitimate charge. That charge should be thrown out. Doesn't mean the judge will, but the felony murder charge makes no sense in the Brooks case.
All right. And we got Bra 3.0. Thank you very much for the super chat. Washington mandated face masks statewide until there is a vaccine or cure. Seems unconstitutional. A step toward making us compliant with government. Since this is not the topic, would you consider making a video about this? Stay bubbles, Mr. Fry, and hello, Mr. Barnes. It's gonna come up sooner than later because we're having a similar discussion in Canada. And
I think it's got to be challenged. What happened is this was passed in the 1920s. It never reached any high court, so nobody knows. But my view is if we can establish that it has to be clear, that it has to meet strict scrutiny, then I think the mandatory mask can be stripped. If we can show that there should be at least exemptions for people for whom it triggers anxiety, for whom it triggers other health issues, for whom already have other health issues, then I think that's at least part of the way there. But these mandated masks for forever, there's never been a successful flu vaccine that I'm aware of. I mean, the flu vaccine has always had a low success rate. There's never been a 100% successful flu vaccine. The last time we tried that was the swine flu vaccine, 1976. That led to a bunch of people being neurologically damaged and some dying more than were ever harmed by the virus. So I'm not a fan of rushing a vaccine for any kind of flu-like virus or making any public policy contingent upon its availability.
It's amazing. I'm gonna bring up the super chats and we're gonna read through them. But thank you all. I don't think we're gonna get to all of them if we want to have a chance of getting to the subject matter. Undoubtedly, the face mask issue is going to come up. Maybe not in Canada because we're much more compliant, it seems, in terms of doing what
that old British history.
I have no comment, but it's becoming an irritant because I first of all, anybody who's sufficiently nervous about being outside in general, it seems that we're having things backwards where instead of them staying home to accommodate to their issues with fear, it's imposing a burden on everybody else, a burden that has not yet been proven necessarily in terms of certain open spaces, close proximity, yes, and hospitals, yes, and can understand. But, going into grocery stores, I see people wearing them in open area parks and fumbling them up and down so they can talk on their phone. It's madness. And it just becomes like this game of the government imposing these insane, meticulous rules instead of focusing on the broader issues, which would be, protecting old person home type things, which is where all the fatalities are occurring in any event. Okay, I won't be able to get the super chats, but thank you very much for all of these. Robert, let's get into this. Flynn, is he a free man or not yet? Because I said he was. I entitled my video "Free Man," and then I realized he's not yet free until Sullivan actually follows through on the mandamus that the Court of Appeals issued against him. So what's the time frame? What's the next step?
He stayed it pending the Court of Appeals possibly taking the case en banc, but he did not request an en banc review. So and no one else is either. So that means now what happens is the way the Court of Appeals work is that when a 3-judge panel issues a decision, the entire circuit, that's what they call it, en banc, can, if they decide, take up the case. Extremely rare that they do. Often only when there's a conflict with an existing decision. This case was not in conflict with any existing decision. So Sullivan simply left open the option of the en banc appeal being taken. Once that doesn't happen, then what they call the mandate from the Court of Appeals issues, then he has to dismiss. So, there's about a 99.9% chance Flynn will be a free man by July 4th.
By July 4th. So, and for anybody who doesn't know what happened, and we all know what happened with Flynn from the beginning. We did videos and we did discussions on the amicus brief that was filed before the Court of Appeal hearing. We talked about the Court of Appeal hearing where arguments were made. Court of Appeal just came down 2-1. Who was it? It was Bush and Trump judges against the Obama judge. The 2-1 said Rule 48A has to be, interpreted narrowly, strictly, only exceptionally to be applied. It was to prevent prosecutorial harassment. They said that basically what the judge had done here was effectively hired his own prosecutor to argue in opposition to charges that were being dropped by the very prosecutorial entity that presses charges. Basically, they came down on the side of exactly what was argued in the DOJ's motion and Flynn's. The Obama judge said the Obama judge said Sullivan hadn't decided anything. That there's no clear right to the remedy being sought. So mandamus is inappropriate. And there was another exercise there where he said it allowed for additional inquiry by the judge before granting the motion. So I don't know if anybody can hear a screaming kid, but they might be screaming and even more tired. Robert, obviously you read the decision. Who do you agree with? And what do you think of the dissent's opinion?
So, I think the decision ended up being exactly what we predicted on the show a couple of weeks ago. After there was the majority legal opinion out there was that the dissent was going to be the majority. I argued here that was not going to be the case, that Henderson, the Bush judge, would likely side with Judge Rao, the Trump appointee, because of the consequences of not wanting other judges to open this Pandora's box to becoming de facto prosecutors like the European system does. And so and that's exactly what happened. And the nature of it, the dissent, I can tell you that same dissenting judge with about 95% predictive accuracy that if this was a Obama or official that was on trial, would have issued the exact opposite opinion that they did. I have increasingly low respect for a lot of Obama judges. They're political. In a political case, I can predict what they're going to do based on the politics. And that same judge 2 years from now, if it's an Obama defendant, will reverse themselves with ease. It's very unfortunate to witness how overtly political they are. And I found the dissent unpersuasive because the problem was if Sullivan had simply failed to rule, had done nothing but failed to rule, then there was an argument that they should wait until he makes his ruling before asking for the writ. But that isn't what he did. He appointed a special prosecutor effectively to prosecute the case against both the government and General Flynn, and was green lighting discovery and additional prosecutions against him. So the nature of it was such that the point that the majority made was that this goes directly against the executive prerogative to protect the executive privilege about what decisions they make and what motivates their decisions. And that given that it made no sense whatsoever to move forward. Sullivan's great mistake here was appointing the amicus. And then the amicus made clear just how ostentatious and over the top he was going to be with his argument. So the Court of Appeals knew that this was going to be a circus sideshow, and there was no way they were going to let it happen. And so that's what convinced Henderson that she couldn't allow that if she had confidence that Sullivan would make the right decision and was just go through a few rigmarole and make a few political points at a hearing, Sullivan might have had his opportunity to get the writ denied. But he appointed an amicus, threatened contempt, which itself was bogus. It's another time Judge Sullivan can't interpret basic criminal statutes. What does that tell you about federal judges? They can't interpret a basic criminal statute, just like he couldn't interpret treason. And he's been on the bench a long time. So these were embarrassing rulings by Judge Sullivan, and the only remedy was he couldn't help himself. So the Court of Appeals had to help him by telling him what he needed to do, and it will happen.
And so, and this was actually one of the things that I read the dissenting opinion. I might do a separate video on it just because, Robert, I mean, you've read judges before. There is clear animosity between the dissenting judge and the majority judge, like personal animosity.
No doubt about it, but in particular because Rao took apart the dissenting decision in their own. You'll usually see in a majority opinion some reference to the dissent, not here's the 8 reasons why you're wrong, and it was just piece by piece. It was just shredded it to where the dissent, had no real argument left that beyond a political one. And hey, maybe Sullivan will do the right thing, so let's wait. That ship had sailed. So and to argue what the dissenting judge was arguing was just not a very credible argument. But I've noted Obama judges take things personal. They're very political, and they've been taught to bend the law to fit whatever outcome they want. And they believe that they convince themselves that their argument is a legal argument when it's an overtly political argument. And everybody in the room but them knows that's what's happening. And it does trigger this degree of antagonism on the court because it's hard to deal with these kind of overtly. We've never really had judges this overtly political since the 1930s, where we had a vestige of a whole bunch of old school economic conservative judges who were creating crazy constitutional interpretations to strike down things like child labor laws. And it took FDR saying, well, maybe I'll add nine Supreme Court justices for them to go, oh, okay. Now we get the message. So that's the last time we had judges this bad, in my view. We've had judges in the South between 1880 and 1950 that were a joke, that denied civil rights forever with every shenanigan known in the book. But this is pretty bad, and I think you see the intensity of it reflected in the difference between the dissent and the majority's readiness to tear apart intellectually the dissent in their own opinion. I mean, almost half the opinion is tearing apart the dissent.
So for anybody who hasn't read the decision or hasn't seen my last video on it, I think it was easily, in substance, 50% of it. They went through Sullivan's arguments, then they went through, I think it was 7 or 8 points of addressing each argument raised by Wilkins. Sorry, who was the dissenting opinion again?
I believe that's the dissent.
Wilkins. Yes. And you read it before you read the dissenting opinion, so you already, if it's not going to influence your opinion, it will invariably. You get to Wilkins' opinion, and it's already been destroyed by the 5 preceding pages of the majority decision. But one thing that Wilkins said in particular that it just seems untenable was that this should be viewed only from the prejudice to Flynn and not to the prejudice of the system, the executive branch, and the separation of powers, because Wilkins says the government is not the one asking for this writ of mandamus, it's Flynn, and therefore the only prejudiced party we should be considering right now is Flynn and not the government, whereas the majority said no, because if this gets by and if this passes and we see judges authorized to do what Sullivan is attempting to do, you're basically empowering every judge to act as prosecutor in their own case, totally usurping the executive power, prosecutorial power. And I read the majority and I read Wilkins' argument. It was shallow and superficial. It's not a question of being biased. It's just a question of not addressing the inevitable, that it's not, the government doesn't have to make the writ for the petition for the writ for the petition for writ of mandamus. They clearly stand to suffer prejudice to the system itself if judges are authorized to do this.
Exactly. And they effectively joined it. So they were relying on, trying to rely upon a sort of procedural, technical out to say, well, technically it was initiated by General Flynn, so let's pretend he's the only party here, is effectively how I read the dissent. And that's just not credible. And maybe at one point that was my guess is what happened is Henderson would have normally written the opinion as the senior judge, and they both wrote their opinions, and then Henderson decided which one she was going to join. And so I think that's why what you're seeing is so strong. And Henderson and that's why the dissent was like, hey, you don't have to deal with the executive branch because technically they didn't initiate the writ, and it wasn't credible given what had happened in the briefing and oral argument.
Okay, and now actually Fozzie Bear says, can you talk about Sullivan ignoring the writ of mandamus by suspending the case instead of dismissing it?
He hasn't ignored it. The writ technically does not issue until the Court of Appeals has a chance to decide in a 14-day time frame whether or not to review the case en banc. So the mandamus becomes a mandate when that time period elapses. So until then, that's why he's suspended. That was not people interpreted that as him trying to do something that actually wasn't. That's what he's supposed to do, is just stay everything until that happens.
And the 14-day en banc, which means in bench in French, that is as of the date of the panel issuing their decision.
So exactly, it was they issue their decision, but it doesn't become a final decision of the Court of Appeals until the Court of Appeals time period to consider the case en banc. They're given 14 days to decide whether or not they want to take it en banc. Then if they do decide to take it en banc, then that's its own schedule. But typically speaking, they deny. I don't see them granting en banc review here.
Okay. And does the en banc review have to be specifically made by one of the parties, or is it sort of like a de facto automatic appeal that the bench would decide to review it not on petition from one of the parties?
You can request it, but I don't think anyone has. But the other thing that can happen en banc is a judge can. So it wouldn't surprise me if the dissenting judge has requested en banc review by the rest of the panel. But I'm pretty certain that Obama does not. There aren't a majority of Obama appointees on the D.C. circuit anymore. So I don't think they'll take that gamble, and consequently, I don't see them granting en banc.
It's amazing because the majority decision was meticulously drafted. I mean, I couldn't see how they would decide to do it, let alone then overturn the majority decision, given what the majority already said, which this would effectively allow judicial usurpation of executive power. I don't see how they could even entertain that idea, but it'll be interesting to see if it goes there. Let's see. I'll just read this one. Do you think they'll get away with this? This is part of the Russian narrative where they used to use by MSM to basically ruin and taint the population against Trump for over 3 years. It's sinister. It's a matter of, I mean, I don't think some people would disagree with you. I think other people might. So you're saying that the Obama judges think they're making legal arguments. In reality, they're making regal arguments. Real Bambunga with the pun. And now we got Uncivil Law who says, you're saying legal would have been a fantastic Obama judge appointment.
That's your example of they do have a little higher IQ than illegal eagle. Well, that's all I can say.
We're going to talk to. I'm trying to maintain cordial relations with legal eagle so that maybe he can explain his lawsuit to me in a live stream, because we'll get into it. It might only be a 5-minute discussion. So, okay, so 14 days by July 4th, we'll know if the full Court of Appeal is going to take it en banc. If they don't, then what? The next day Sullivan has to, or is it sort of like an automatic issue?
What happens is the mandate issues, and as soon as the mandate issues, then that's the writ ordering him to do so. He'll dismiss the next day. And
I mean, does he have to sign it? Does Sullivan have to sign the writ personally?
He signs the order of dismissal.
It's amazing. And now, I said it in the video. I'm curious to know what you think. Did they not remove him from the bench out of spite, out of shame, or to allow him to save face?
That's Henderson. Henderson has a personal relationship with him, was on the bench with him at the district court level. So that was the only argument really that the dissent really could have had, was to protect Sullivan's reputation. But ultimately, the procedural posture didn't allow that to happen. So that's Henderson saying, no, we'll let Sullivan fix this. I'm not going to smack him across the face for what took place. The order is sufficiently makes clear what the law is, but without embarrassing him personally. The opinion says a lot of things that would be embarrassing to most judges already.
And so it would have been more embarrassing to reassign the case than to force him to issue the writ.
Correct.
Okay. Because there's some people are saying, they left him to rub his face in it. Others are saying they didn't reassign him because that would have been rubbing his face in it too much. So you could sort of read the same thing both ways. I thought part of me would, part of me thought maybe they were really rubbing his face in it by forcing his hand to issue the writ, whereas reassigning it, could have been explained away through other justifications. But
more than a few judges have had to reverse themselves by writ. Reassignment is very rare and considered very embarrassing, and it becomes an issue in future cases. So it's a sign that you are so biased you can't be a judge. Getting the law wrong and having a writ is embarrassing, but not humiliating. Being reassigned is a sign that you're so biased you don't belong on the bench, basically. So that's they avoid that at all costs, and judges find that much more humiliating.
And so we're going to bring up Isaac Castillo, who says, what's your take on Judge Sullivan saying he's not required to rubber stamp DOJ's bid to dismiss Flynn's case, reported via Washington Post? One thing I have found shocking, I mean, I say shocking, disheartening, surprised but not shocked, I guess. The media reporting on this is madness. I mean, it's like there hasn't been a judgment. They just repeat the same thing, dismissed despite the fact that he pleaded guilty. The rubber stamping argument that they're still repeating. This was another superficial thing. Sorry. Go ahead, Robert.
Yeah, I was just going to say, and additionally, the New York Times has a hit piece out, I think today, in the Sunday New York Times, saying that this was all dealing with backdoor lobbying by Sidney Powell and the Justice Department, which is a bunch of nonsense. What Sidney Powell did is she made clear to Barr up front, this is a bad case. I'm going to expose it as a bad case. I'm going to give you the professional courtesy as the Attorney General of the United States to have an opportunity to fix it before it becomes a really bad case. I've done this multiple times. I've explained this to all political actors in a range of cases I have. It's like, this case will be embarrassing. You can either fix it now to limit the damage to the institution, or you can suffer the consequence. And in every single case where they have gone forward, where I've made that prediction to them beforehand, they have been embarrassed and humiliated. There was a prosecutor who figured out mid-trial that he was about to be humiliated. He did a sweetheart deal for my client, and now he sits on the federal court because of that, because he figured out, oh, Barnes was right. I got to get out of this thing. So so they're trying to make ordinary, everyday activity by professional lawyers look illicit and suspicious. It's ludicrous, the behavior. What has been exposed, and I don't think my friends on the left recognize this, is like all of them signing these letters objecting to Barr, dismissing, and all the rest. They're exposing just how politicized and partisan the prosecutorial branch has become over the last decade or so. And I've been complaining about it for a while, dealing with prosecutors who don't look at facts, don't look at evidence. There was a recent Billions episode, Showtime, great show if you understand the criminal process, how it really works, where these young interns come into the prosecutor and they're like, you've assigned us a project where we're supposed to, we know you just give us the man and tell us to find the crime. That seems unethical. And he demands they all leave. Because he goes, anybody that doesn't put loyalty first to me needs to go home now to Yale Law School in the show. That's the real mindset and mentality of a lot of these prosecutors, and they've politically corrupted justice in the United States, and they think they're championing high ethics when in fact they're exposing their complete lack of ethics, and they don't understand how much damage they're doing. The last bastion of people who believed in law enforcement were conservatives. The people on the left have long had doubts about it. African-American community has experienced enough bogus prosecutions to have doubts about it. People in lower income communities, the Latino community, already have personal experience that leads them to doubt it. The last group of true law enforcement supporters were conservative Republicans, and they now have been educating them how political and partisan and corrupted the process is. The FBI is going to have a record low level of approval in new surveys. Justice Department's going the same path. Now, as a defense attorney, I don't mind that. I like the public getting educated on the reality of the situation, but they don't realize how much they're damaging their own institutions and the credibility, because these institutions only have power to the degree people believe in them. Once you have 20-25% of juries who no longer believe in it, you no longer can secure convictions. You can no longer secure confidence in judicial rulings. So they should learn to realize they don't have the power of the purse. They don't have the power of the pen. They don't have the power of the sword. They need to step back and recognize that their whole power is based on the credibility of their institutions, and they've been wrecking it wholesale with the last several years, and particularly bad in these cases. And not only that, there's another reason why Barr got dumped this case is because more bad evidence came out. I mean, the most explosive evidence related to General Flynn they had been hiding all along only came out a day or two before the writ issued. And what it was is Peter Strzok's own internal notes that show this was an Obama-driven plan to get Flynn, and that Vice President Biden was neck deep in it. And so it shows Sally Yates, corrupt prosecutor, been dealing with her for more than 10 years. So anytime I get a chance to tell people Sally Yates is corrupt, I do. I might be having a beer with somebody and tell them, by the way, Sally Yates is corrupt. So she went after a good client, a good friend of mine from Atlanta, bogus prosecution, put him through hell for 10 years, did to General Flynn what He did to him for 10 years what they did to General Flynn for 3 years. Almost ruined his business that employed people, disproportionately working class people from different African American and Latino backgrounds. Just incredible what tried to do. So this was a corrupt group of actors who's been exposed. But I think Barr needs to take follow-up action to prosecute some of these people in order to restore confidence and faith and the impartiality of our justice system.
And to the rubber stamp question, it was in the majority and the dissenting opinion where dissent said the judge is entitled to an inquiry. The majority said, yeah, this was not a 3-line motion. Please drop the charges. This was a highly meticulously detailed, I forget what it was, 40 some odd page motion detailing the new evidence, giving all the consideration that the judge would need to, if he wanted to have a hearing, listen to the motion. It was not a question of rubber stamping. It was just a question of not opening up a debate, a Pandora's box, chasing windmills, inviting a hostile amicus to come and reopen debate about other issues that had nothing to do with this, basically to explore the prosecution's decision-making process. There's a fine line between a rubber stamp and a full, I don't know what's the word I'm looking for, investigation.
Well, and the reality is, as long as there's not prosecutorial abuse taking place, the job of the judge is to rubber stamp the executive branch in this context. So the rubber stamp language never made much sense to me. That's the judge's job when the executive branch says there's not probable cause to move forward.
Yeah, Sullivan could have had a hearing on the motion as drafted, could have done whatever inquiry he thought necessary given the file, but instead decided to hire his own prosecutor to create his own file to counter the already complete file that was presented by the DOJ. It was not a question of rubber stamping, and any outlet repeating that rubber stamp didn't read the decision or didn't understand it. And Talix001 says, from what is known now, released documents, this is speaking to what you just said about pressing charges against someone, Barr should hit the FBI up. What charges, if any, could be brought and against whom? With the known public information, surely some charges with the known info could be brought.
I mean, clearly against the prosecutors, they were hiding evidence. Clearly against Peter Strzok and others. Anybody that was sort of complicit in this process. And truth be told, now I don't think they're going to go there, but I do think this came from the top down. I think it came from Obama, based on Peter Strzok's notes. Basically, and that was always clear with Susan Rice's bogus CYA email she wrote on the eve of Trump's inauguration. That was almost a telltale indicator that something deeply problematic had happened at that meeting in the Oval Office, and now all the evidence mounts towards that. The case was going to be closed. Even James Comey told Obama there was nothing wrong with Flynn's calls, and Obama said no. And it was Biden who said, hey, what about the Logan Act? And then Sally Yates went and acted on it. And then they set up the entrapment meeting. And then they did bogus charges. And then they hid the evidence of what took place. So there's a lot of people who could face consequences. I'm not overly confident that a lot of people will. I hope so. But because I do think Barr is serious about cleaning up at least the appearance of integrity in the Justice Department. But so far, there's been 0 prosecutions. 0. Mueller didn't take this long to act. That's for sure.
And will Flynn be able to get legal fees? I mean, we mentioned it earlier, but is it becoming increasingly possible or just still unlikely?
He should definitely sue that law firm. I've told his people that sue the Covington law firm. I'll be happy to assist.
But now there's two ways to get the fees back. One would be to sue his conflicted prior law firm. The other
suing the government's a waste of time. It's almost impossible.
Okay, and we got thanks for the vlogs. Shout out to Mandy Amos. Now, I just forgot how I wanted to end this. The bit was the rubber stamping we were talking about. The corruption, that was it. Other headlines repeating the fact that he pleaded guilty. And again, any article repeating that he pleaded guilty without citing the newly disclosed evidence, which was withheld from him. Okay, I guess it'd be a good time. Explain to everybody what the Brady requirements are, the Brady disclosures. I think everybody knows, but just in case.
Sure. So it comes from the Brady case, and it's all about the due process clause of the U.S. Constitution, which is that you are under the due process clause. The prosecutor has a duty to provide any information to you that could be helpful in preparing your defense. And that's not just for trial. Now, some courts have tried to limit it to trial, but that was not the intention of the Supreme Court's principles in it. The intention was anything. That means, could it impact whether you plea or not? Could it impact what discovery you seek? Could it impact whether you go to trial? Could it impact your appeal? And here they clearly withheld all the critical information that would have motivated him to take a different path. So they withheld information that could have been helpful to him. And that's the standard. Is there information I, as a prosecutor, am in possession of or can get access to that could be helpful to the defense?
And because if Jennifer is watching this, I won't mention anything more than that. The question was, I was talking to her about this. He pleaded guilty. He pleaded guilty based on the evidence that had been disclosed to him at the time. He pleaded guilty based on the understanding that they would not prosecute his son or not investigate his son. That was known to Flynn at the time he pleaded guilty, but not known to the general public as to how the FBI goes about it. That was subsequently released to the general public, I guess, to color or at least to enlighten our understanding. But he pleaded guilty based on the information at the time to save investigation of his son after 3 years of prosecution, promised no jail time, or no a slap on the wrist in terms of punishment, but had already gotten fired and already gotten prosecuted, which was exactly what the FBI wanted as per their notes. Get in front of Sullivan. Sullivan starts talking things like treason. I might sentence you nonetheless. And then at that point gets a new law firm who obtains this information either that his former counsel had, but had not disclosed to him, or did not obtain from the FBI. I'm unsure as to which it is. And then gets these newly disclosed piece of evidence which show the malicious intent of the FBI in all their dealings with him from the very beginning. So if knowing that does not attenuate your understanding of him having pleaded guilty, that's a question of discretion or judgment and not a question of knowledge of the facts. Did his prior law firm know of the FBI notes? Did they have them in their possession but didn't get to them, or did they not have them?
They didn't request them and didn't have them.
Okay. So
the other aspect there is, of course, they had conflicts of interest, which made it such that he did not get adequate legal representation in that process.
Yeah, the conflict of interest, and that was another thing I was explaining to people who may not understand that, but they should if they've seen our previous vlogs, that Flynn was facing certain violations as it relates to FOIA, the Foreign Agency Registration Act.
Also insane. Only been 6 prosecutions on that in history. Never been a prosecution of the Logan Act in history. Major constitutional problems with it. He didn't even violate it if you even considered it something worthy of looking at for prosecution. Number one. Funny that Joe Biden would think of the Logan Act. There's a guy who's been violating every law known to man for decades. But put that aside for the moment. Joe Biden would know all the laws that govern potential corruption involving foreign officials. Let's put it that way. He may have been briefed on that in multiple contexts. But the other is that the FARA, the Foreign Agents Registration Act, also has constitutional problems. It's only been 6 prosecutions in history until these cases were brought. Tony Podesta, John Podesta's brother, was never brought up, even though he was far more culpable than Paul Manafort was. Paul Manafort was effectively working for him. So all of that was bogus. The Turkey-based prosecutions ended up being thrown out by the court. So in the Flynn related cases in Virginia said the evidence didn't support it at all. So it was all based on bogus threats, bad legal advice, withheld information to coerce a confession, and false confessions happen all the time. I can get you put like I said that great film, which has Gene Hackman and Morgan Freeman in Puerto Rico. Just watch that film to remind people why false confessions are the least reliable evidence, other than eyewitness testimony, that exists in our criminal justice process.
Yeah, false confession. I think people need to appreciate that. And I was explaining my learning curve from all of this, because I started off from the get-go as he pleaded guilty. He must be guilty. He got fired, and he got what he deserved. And only through this journey did fully understand. I mean, a lot of the information only became available in April 2020, so nobody knew this beforehand, and madness. It's absolute madness. Mike Brown says, so who or what holds Sullivan accountable for his unlawful, unethical actions? Wouldn't an attorney who did something like this face a disbarment?
Only a defense attorney. Prosecutors, they did a study a couple of years ago. 2,000 prosecutors who were found as part of a judicial record to have committed grievous, severe misconduct. Only 2 of them ever faced any ethical consequence. So the probability of facing a consequence of even prosecutors is very low. Judges, pretty much never. Only time a judge has to get caught taking a bribe and be politically disliked for anything to happen to them. And even then, they usually get impeached. Like I said, one of them is sitting in Congress right now from the state of Florida. So, he got impeached. He committed bribery, and now he's a congressman. So that's what happens to judges. They only get hammered when they go against the powers that be, not when they go with the powers that be.
Okay, amazing. And I just pulled this. I put up Matthew Christ's press X if Yates and Biden Obama holder are corrupt. And now I'm looking at the chat, which is an interesting response. Okay, I think that does it for Flynn. That should clarify all of the lingering questions as to when he is officially a free man if the Court of Appeal takes this up en banc, which we'll know by July 4th. And what a fitting day, incidentally, that is. So this can't get dragged out very easily to November unless the Court of Appeal takes it up en banc and says, now we got to set up a schedule.
Correct.
Okay. Good enough. We got to do it. We got to do it because I got to know. Have you by any chance read Legal Eagle's lawsuit against the Department of Justice, NRAIC, the government? Have you got your hands on that?
I always put an asterisk by a FOIA suit. I do a lot of FOIA suits. So as soon as I actually, because YouTube, of course, bombarded me with recommending that video. So I was like, okay, fine, I'll take the bait. Legal Eagle claims he's suing somebody, suing the government, And I was like, oh, it's a FOIA suit. Okay, that's just a suit for records. The government's named, but it's not like you're suing them for damages or you're suing them to change the system or change the law. Now, I think FOIA is a very underutilized law. The Freedom of Information Act is great. People don't realize that between it and the Privacy Act, you can get all the records the IRS has on you. You can get all the file the FBI has on you, CIA has on you, State Department has on you, ICE has on you, almost anybody. So you get a wide range of sources. You also can get records about people that are dead. That might be interesting for historical purposes. FOIA is often what produces a lot of great discoveries and disclosures about past government corruption. So FOIA is a great law to utilize. The left has weaponized it against the Trump administration aggressively. They've used it to a whole new scale than it's ever been used before. But Judicial Watch uses FOIA a lot. That's how all of Hillary Clinton's email scandal came about, just because Judicial Watch brought a FOIA lawsuit. So I call those FOIA lawsuits rather than lawsuits against the government, because they're not quite, technically, yes, they're against the government, but really they're just FOIA lawsuits to get information that the government won't turn over. His particular suit did not strike me as credible. Because what he's saying is he's trying to presume something in order to get something. He's trying to presume that Bolton's book did not have confidential information in it, that the government corruptly precluded the publishing of the book on those grounds, and that thus he wants that information. The problem is the information clearly was classified. A judge who's already reviewed the information in the lawsuit that Bolton had with the government already concluded that classified information was there, that Bolton's already improperly disclosed it. So now he's going to be subject to criminal prosecution and forfeiture of all profits. So I don't see that lawsuit getting anywhere. It presumed a fact that was not true. The second part is, even if Legal Eagle was right, as a general matter, courts defer to the government's claim of what is classified. Normally, all you do by suing when you think that something's not really classified is sometimes the judge will review it in camera, they call it. Mm-hmm. So he'll review it privately without any other party seeing it and decide whether or not it's classified. But here we already know that what that outcome is going to be, because the judge has already said, yeah, this stuff was classified.
And incidentally, that was one of the questions I had internally, publicly, was I read the lawsuit, then I watched a couple of his videos, and it made the question was answered somewhat, but I couldn't get clear if the lawsuit as drafted was looking to identify that information which the government said was classified but ultimately was not in the book, or if it's actually saying disclose the information that was in fact deemed classified in the book as per the court's ruling, so that we can see if it was in that incorrectly retroactively, or what was it, retro classified, or if it was legitimate or not. And and
it was also a third aspect. He wanted to know what their internal procedures are for determining how their whole internal book publishing process goes, what procedures they utilize to determine whether there's classified material in a book or not. And there's a popular contention of things being that, this has only been retroactively classified. You do not have to list something as classified at the time. So you don't have to have every conversation or note have a stamp on it that says classified for it to be classified. That's an objective determination based on the content of the information, not the procedural formality of whether a stamp was applied to the letter or the note or the recording or anything else. So they've been trying to do this a lot. They did this in the Hillary Clinton emails case. The defenders of Hillary Clinton were like, they went back and later put classified on it. No, it was always classified. You don't have to put a label on it for it to be classified. So that's people get that from TV shows and movies where it says classified on it. That's not the way information typically is processed or stored by the government. They don't do that they do that, but it's not a required protocol and it's not universally applied. What matters from a legal perspective is it objectively classified material, which meets a certain set of standards.
And the power to classify documents, am I understanding it right that it's the power is by executive order, that the executive has the privilege to declare things classified?
Absolutely.
And I was looking it up. I mean, the orders seem to be amended, be rescinded, be overridden by subsequent orders. Does each president come in with their own, call it classification system that they implement by way of executive order?
Classification system pre-exists, but what it is, the president can override at any time. So the only you can't like completely abuse it. So there's certain context in which the information can still be turned over. So that goes back to the Nixon tapes, where they said that some of the Nixon tapes could be compelled to be turned over. So it's not like you can just unilaterally call something classified and that never be challenged. You have to have some basis for it. But what the president can always do, it's not so much he has power over classified, he has a great power over declassified. The president can just declare something declassified at will. And then it's no longer classified, even if other people wanted it to be top secret, even if it fit the standard of top secret, the president can pretty much declassify anything he wants, anytime he wants.
And I imagine that the process, I mean, I'd like to know, what is the process if one suspects that something has been abusively or maliciously, falsely classified for the purposes of preventing disclosure? Like what process has to go into having that disclosed to the public?
There's both procedures that people can find that are published where they outline what constitutes classified material and the level of classification. Because this also came up in Comey's release of his materials to his law professor pal, that he claimed they weren't classified. An objective determination by the inspector general determined that much of it was classified, because that's an objective test. And so it's basically the way to think of it is it's almost like trade secrets, except it's a little bit more broadly and liberally applied in favor of the government. So if it's information that is the kind of information you wouldn't want public, not because of its embarrassing qualities, but because it would disclose methods, it would disclose information gathered, it would disclose mindset. It was almost inescapable that almost everything Bolton had was classified because of his role. He was the national security advisor. He was sitting in on conversations, and he's dealing with the president's intent. So you're disclosing how he thinks, you're disclosing what he thinks about things. You're the national security advisor. You're not the janitor. So
It first of all, it blows my mind. I mean, it blows my mind, say, culturally between Canada and the US, we don't have this type of, I call it nothing more than exploitation, because it's almost as though you're looking to make money off your appointment as opposed to serve with loyalty. But the idea that he would publish the book during the presidency, I mean, I understand, do it 5 years later, like sit on that, leverage it, maybe invest in what you're going to make 5 years down the line, but to the extent that you're even allowed to do it. But the idea of doing it the way Bolton did it during the presidency, whereas given his position, it seems unconscionable. And I don't know what you would have to do to prevent it, just to say you have no business writing a book during the term or within a certain period afterwards, regardless of whether or not it's classified. But this is it's just mind-blowing to me, because it does seem borderline criminal, but I say borderline, and I want to bring up Mark Watson's comment: odds of Bolton being sued for the classified material and risking personal or financial damage.
It's already happened. The court's already found he violated the law. So what the court said is it wasn't going to issue an injunction because the book had already been published. So like the horse is out of the barn, so there's nothing to do there. But what the court said is that all of his profits can be forfeited and he can be criminally prosecuted. It's up to DOJ whether they criminally prosecute him or not. But I guarantee you they're going to forfeit his profits. So he's not going to make a penny from that book.
Which is, I read, I think it was Turley, actually, Jonathan Turley. He said, there's no solution, there's a perfect solution. Publish the book, go after him civilly, and seize the profits of his book. And because apparently people are not very happy with Bolton on the left and the right. The left hates him for being a coward, the right hates him for being a traitor. So a punishment for Bolton would make everybody happy.
I think it would. I think the X factor here is I have a strong hunch that Bolton has been paid by foreign governments, independent of the book, that want Trump out. And so as a quote unquote consultant. And so I think I think that's what should be investigated criminally, whether or not there was a foreign government payment to Bolton in order to damage the president, and that he was a true unregistered foreign agent in all of what he was doing. I think it's why Bolton wasn't worried about the financial consequences of not getting any profits from this book. I think someone else is paying him to publish this book, independent of the direct profits.
It's very interesting, and time will tell, and we'll know that it happened at 1 hour of this live stream, if and when in a couple years' time. And so I just imagined, because I read through Legal Eagle's suit, he made the FOIA request, he got no response or denial, files this suit. I highlighted the paragraph that I tweeted on Twitter, which was effectively paraphrasing, because I don't have my phone. I'm concerned that it's going to be improperly classified for the purposes of preventing disclosure or retro classified. Therefore, I want to know the documents, the system, and I want full disclosure, so I, as a petitioner, can determine whether or not I think it was properly classified and withheld. That's
exactly. And all that's going to happen, if he gets lucky with the judge, who knows? But what will happen is the judge will do an in-camera review, maybe. Sometimes the judge says, no, this is classified in the story. Reasonable determination by the executive branch, defer to it. But let's say they take the bait. I don't think there's enough factual arguments he's made for the judge to really do an in-camera review. That's usually a high evidentiary standard to suggest impermissible motivation, kind of like the Flynn case. That's where they pointed out much higher standard is required. Like, for example, they said the only other context they could imagine other than prosecutorial abuse of a defendant for 48A discretion to be exercised would be the cabined context of a prosecutor taking a bribe. In other words, if the prosecutor's like, hey, I'm going to dismiss the case, and somebody comes forward and says, by the way, the defendant bribed the prosecutor to dismiss the case, and then that might be something worth looking at. Same context here. You usually have to have a higher evidentiary standard than, hey, I just think they're misclassifying information. Because the problem is, if somebody can sue for that, tons of people are going to sue, and judges are going to spend all their time reviewing classified materials and in-camera review. So now if he gets an Obama appointee, they'll probably do the in-camera review. But I don't see it going anywhere, because they have strong protections for that kind of issue. And it may get assigned to the same judge who handled the Bolton book case, because he's already got pre-familiarity. If that's the case, Legal Eagle's screwed, because the guy's already reviewed it and said, yeah, this is classified.
Well, and that's why I couldn't get clear on what Legal Eagle was actually asking for in the suit, given what the judge ordered, that they confirmed that there was a ton of classified material. There's an issue as to whether or not the first person who reviewed, I think her name was Knight, versus the second, who was Ellis, whether or not there was a disagreement among them. But I think even the first person who did the review determined that there was classified information in that book that they removed, but she ultimately gave it the go-ahead, which was overturned later by the political appointee. So I just reading it, it's like, if anybody can say, I think, I'm fearful of, as a justification for examining or investigating the government's classification, everybody will do it for anything, and there is no bar. It's not like there's any concrete evidence of wrongdoing. It's just general suspicion, which incidentally I share with Legal. I mean, I share that of every government, but that I just, reading it, I'm saying that can't possibly be the threshold to justify the citizen verifying the executive's classification or qualifying of classification. That couldn't be it, but we'll see where it goes. I'm curious, and we'll see if I can get Legal Eagle to explain away what he's doing.
You can tell him it's a promotional opportunity for his GoFundMe account for raising
it wasn't a GoFundMe. It was for, I think it's called the Democracy Engine.
Yes.
Whoever the attorneys are, it's a not-for-profit attorneys organization.
Oh, that's probably that fake organization that Mark Zaid, the lawyer representing the quote-unquote Ukrainian whistleblower. I got in a debate with him and his partner. I forget his partner's name. And they claimed it was like it appears to be like a 501c. So I was curious who the funders were. It turned out it doesn't appear to be a 50. At least this prior one they had. They said that John Podesta was on the board, which I found interesting, while they were claiming to be nonpartisan. And then it turned out maybe Podesta wasn't on the board. So we got into a long discussion with it. I think he's also the guy that threatened people on Twitter with certain kinds of retaliatory actions if he didn't like certain things they said. So those guys I don't take seriously. They're a sideshow. Now, who they represent is they represent a lot of people inside government getting national security clearances. Yeah, that's right. They were trying to tell me that there's national security law. There was some class. I was like, national security law? Find me the law class at Harvard that's called national security law. That's just some stuff you made up. Congratulations. I can call anything. Oh, I'm a specialist in voodoo law, whatever. It's not, it makes you sound good. There's no specializations in it. It just means that you're familiar with national security clearance law, but that sounds kind of lame, right? To say, oh, I'm an expert in how you process paperwork over at the NSA. Congratulations. It sounds more authoritative and super secretive and CIA-ish that you're a national security law. Maybe you worked in the military, that kind of thing. So it wouldn't surprise me if there's some connection to those guys, because in my view, they have been using FOIA for politicized purposes while claiming they're nonpartisan. But if it's the same group, and it wouldn't surprise me if it was, that's the group that the president got into sort of a tiff with because of on Twitter, because of prior statements that Zaid had made. And he represented that Yale kid who led to the whole Ukrainian thing. So what it does reflect is a broad scale war that the administrative state is still waging on Trump, like the leaks that came out this weekend that, Russians were giving bounties to Afghanis to cause problems in Afghanistan. And everything about it smacks of fake leak by somebody within the intelligence branches that just wants to undermine Trump or wants us to go to war with Russia, as the Bolton types do. Bolton was crying about all the times they didn't get to bomb somebody. I'm skeptical of a lot of those cases.
And incidentally, I think the firm representing Legal, I remember there being national security in their name, and it's a not-for-profit. I'll double check it. I just can't verify it right now.
Some of those are not real not-for-profits when you investigate. They're just front groups. So what happens is you create you create some organization, you call it whatever you want, and then that organization raises funds to support certain litigation, all of which is fine. I don't have a problem with that at all. It's just a lot of them are not technically non-for-profit charities. Some of them pitch themselves as non-for-profit charities, and then I think that's a little bit problematic. They're trying, in many cases, to disguise their political motivation. They're more like the ACLU, if you will.
It's interesting. You can't disagree with that, especially once you know how these organizations do tend to work. It's
especially in DC. In DC, a lot of them are rotten to. My view is presume they're rotten to the core until they prove otherwise.
And don't go to Charity Navigator for a review of the.
Yeah. Well, it's like, look at what's happening with BLM. It turns out that one of BLM's groups, which BLM's always been weird because their organizational format has always been sort of shrouded in some degrees of secrecy. But there was one BLM group that ended up connected to another group that had on its key board members one of the old communist terrorists from the 1980s who Obama had commuted her sentence. And so that didn't look good, of course. And so immediately they started taking down all their 991 forms and the rest, all the different forms that have charity disclosures, because a true charity has to disclose tons of information that the public can review. And so that's where, if people want to see what an organization is, to trace it and track it, that's the way to do so.
And incidentally, if anybody doesn't know of the website, there's something called Charity Navigator, which is it's a top line review, but you get to see what the CEO makes, you get to see who the board members are, you can get to see how much they make every year, how much goes to the actual charity versus administration, and it will blow your mind. I don't want to put anyone on blast, but there's a couple of big charities that I looked up, seeing CEOs making $500,000 a year of a charity.
Well, take the BLM group, that at least this one BLM group that was tracked, 94% of the money went to just people at the top. Only 6% was distributed to like local groups or anything else. It was purely just a fundraising technique, not a social reform technique.
No, and it's not cynical, because when we were kids, my parents would say you got to watch out for these charities because 90 cents on the dollar oftentimes doesn't go to the charity; it goes to the administration. It's not something that's acceptable.
It reminds me of a South Park episode where they all go to Ethiopia and they find Sally Smothers is eating all the food for the kids.
I never watched South Park. I was into Family Guy before it got PC, if you can imagine that, and I was into Simpsons before they got, I never thought they were on PC, but never got into South Park. But I'm not too old. Okay, Nabadi says there seems to be a lot of Chinese investments into our colleges and to left-wing orgs and politicians. Any advice on how to expose this so we can see repercussions on bad actors?
Keep trying to track and trace the money, track and trace funds. At least the government is doing something on that accord, going after more universities, going after more professors that have taken this huge amounts of money. The Confucius Institute that the Chinese government has helped set up on U.S. college campuses is being looked at more aggressively. Because the Chinese view is anything stolen is good. If you look at their governmental action and how they deal with copyrights and intellectual property. So politically, they'll have the same mindset and view. So there definitely should be a lot more research on that, a lot more public awareness of that. I say in D.C., you can't throw a rock without hitting somebody taking money from a foreign government one way, shape, or form. It's astounding. Doesn't matter which political side they're on either. They're all taking money from foreign governments. I mean, when I was up there, people were trying to hustle me into joining different groups. And they're like, oh, yeah, we can get money from this foreign government. We can get money from that foreign government. And I'm like, wow. And I was just shocked. I don't know why I was shocked after all these years in D.C., but I was still shocked. I was like, people I held in pretty high esteem were all excited about, and this is even people included on the conservative right, all excited about the money they could get from foreign governments. And I was like, that's not good. I mean, it's basically Rome, a new age of Rome, where the people are more attached to foreign governments than they're more the capital of foreign government influence than they are for their local domestic populace.
All right. Well, I unfortunately, Uncivil, I was just about to ask. I know what your favorite bourbon is, Robert, because I saw you tweeted it the other day. What is your favorite bourbon?
Pappy's 23, best bourbon on the planet.
There we go. Michael Adkins says, thank you, Viva and Robert Barnes. I'm so tired of the harmful left pulpit thumping, shove down your throat hypocrisy. Well, thank you for the super chat. I mean, look, there's a left and there's a right, but then there's some universal aspect to the systemic corruption. But certainly now,
well, these days, I mean, in the past, the threat to liberty has come from the right at times, without question. I mean, I was on the left most of the 90s and 2000s. It's just practical reality. The threat is coming from the left these days, ideologically, because they quit believing in civil liberty. They quit believing in the Enlightenment freedoms. They quit believing in freedom of speech, freedom of religion, freedom of thought. They quit believing in the rule of law. And because I've experienced it and witnessed it repeatedly is what pushed me back to the right. I mean, I started off as a kid on the right. And I'd still say I'm sort of the populist right, so I have some different views on some things and strong on the civil rights, civil liberty side, and still skeptical of the state. But effectively, I mean, I think there's a lot of people that are in that boat. 10 years ago, a Mike Cernovich would have been on the left. A lot of these people would have been on the Cassandra Fairbanks was on the left 3 years ago. Tim Pool was on the left 4 years ago. Dave Rubin was on the left 6 years ago. Brett Weinstein still thinks of himself on the left, but completely rejects, but it fears the left more than anyone. So, I mean, that it's the left's radicalization that has returned civil liberties to the political right side of the equation in modern American politics.
Amazing. This is going to be a good segue into the next section or discussion. But Mr. Barnes, Ghost of Record says, I used to live 20 miles from the distillery that makes Pappy. Still haven't tried it. I'm a big fan of Jefferson Reserve.
It's nice. I just like Pappy's 23 because it's so smooth. So I'm not the regular bourbons are a little rough for me. Jack Daniels I can do. Now, that Japanese whiskey that people were praising is legit. I was initially skeptical because
Suntory?
The Santori, and there was a couple other ones that are really good. I was surprised. All I would tell people is if you're at a Chinese restaurant, do not order the Chinese wine. I made a mistake of ordering a bottle of Chinese wine at the Great RG's Lounge in San Francisco, and everybody around me everybody else that was there was Chinese. I was the only a gringo in the room, and they saw the whole bottle delivered, and I noticed they were starting to chuckle and the rest. And I started drinking it and realized this is moonshine. That's what they called wine. But I had to finish the bottle. I couldn't. I was like, I'm not going to wuss out right here. I got to, hold up the reputation of Tennessee. But that thing wiped me out. So I learned don't order Chinese wine at a Chinese restaurant unless you want moonshine.
And we got no question, just praise from Corliss D. Corliss SD. Thank you. Freedom of speech discussion. Let's get to Carpe Donktum because everybody who's on Twitter knows. Carpe Donktum. I believe his description was the meme master. Getting for a Trump meme master. He's a right-wing I feel crazy even having this discussion. He is a right-wing meme master on Twitter. Makes the videos that you've all seen probably. He was issued a permanent suspension, which I love the Orwellian description of, banned from Twitter because of the toddler meme, which allegedly violated copyright of the copyright holder and because he had too many copyright violations on Twitter, exercising their duty to ensure compliance, banned him, presumably to remain in compliance with DMCA provisions. Now, so this is where the discussion is. Like, I don't know the details of what notices were sent to Carpe Donktum, if it was a bona fide DMCA takedown notice, if it was a complaint. But for those who are wondering, in general terms, when there's a DMCA takedown notice on copyrighted material, there's a procedure by which the recipient can file a counter notice. There's a delay within which the issuer of the notice can respond. This is all above and beyond the terms of service of the platform, but could you elaborate on that? And before you do that, actually just satisfy everybody that you know what you're talking about and give your credentials on the subject.
Sure. So the copyright law is an extension of intellectual property law, and it's mostly statutory in the United States. First one was in the early 1900s. They amended it with the Digital Millennium Copyright Act in 2000, and that's where the DMCA acronym comes from. The point and purpose behind copyright law, and the reason why I've litigated a lot of these, I got a notice from the federal courts that I got some sort of designation. I was in the top 10% of copyright litigators last year. It's because copyright law is being weaponized it's being weaponized by two different groups. One group is often called or labeled copyright trolls. The other is by people on the political left who are weaponizing it to go after their adversaries in the media and the press. And so Alex Jones and InfoWars have been a constant target of weaponization of copyright lawsuits. So I represented them in certain cases, represented other people in other cases. And it's really sort of exploded in the last couple of years. And the copyright trolls come from a different group, which is that an interesting guy, actually, a lawyer in New York who's often accused of being a copyright troll, but I actually found him to be a relatively reasonable lawyer compared to many of them, is that because of the modern web, everybody uses photos in particular and often recirculates those photos. He was a photographer before he goes to law school. Goes to law school and he's like, wow, there's a lot of potential here in these copyright cases. So he signs up a bunch of his photographer buddies, and he figured out, rather than write a letter to somebody and say, hey, I want my photographer's fee for $250, I'll just file suit. And then I can probably get $5,000, $10,000, $20,000, something like that. And I think he filed something like 300 federal lawsuits last year. So I mean, it's that, and so he has a bunch of people going after him because of this. But it's technically what the law is. Now the question is whether it's getting disproportionate. So that's the copyright troll category, quote unquote. The other category are the people that are weaponizing it. And what it is, they just look at everything you've ever written, every photo you've ever printed, every video you've ever broadcast, and look to whether they can make a copyright claim. And some of these groups are politically motivated, not even lawyers. There's these quasi-lawyers that have opened up everywhere that represent photographers and other people, and they send you notices. I got one on my own website. I printed an article that had a photo in it from another website that was linked to that website, and they're like, well, we're going to have to sue unless you pay us. And I was like, you got to be kidding me. That was a couple of years ago, but that's when I woke up to how bad it was, started doing that kind of representation because I dug into the law for my own benefit, had done it back when I was a kid lawyer. And so gotten some law school award for intellectual property and all that jazz. So it was an area that came natural to me. I also had a client maybe once who, let's just say they had a creative view. Their wife was from Vietnam and she had a creative view of copyrights. Let's put it that way. On a mass scale too. Wow, that was something. But so that dynamic led me to understand all the intricacies of the law. For people to understand that there's the formalities of the law, but the policy behind the copyright law is about protecting creativity and not having someone steal and get profit from your creativity. The purpose of the law is not to prevent or punish creativity or to give you like a patent on your idea. It's not like a drug. It's not like a design. So copyright law is much lower protection than patent protection because the policy they're protecting is creativity. And so that's why there's a broad option for what's called fair use. So if you, there's doctrines like abandonment. So like that came up in the Pepe case and the InfoWars case, whether or not they had abandoned the copyright because they'd given it to other people, that kind of thing. And so you can abandon it by just letting a lot of other people use it. But fair use is we want to protect creativity. So in memes in particular, they were the perfect group. Now, you've commented a lot, to give you how broad fair use is, you've commented a lot on Sargon of Akkad's case. And there, he just took her video and put it up. And he did nothing else to it. And yet the court said that was so obvious fair use that it was frivolous basically to file the suit, dismissed it right out of the gate, and now is going to issue attorney's fees so that Sargon's going to get to collect from her. So what's been happening, it's been happening on YouTube a lot, Twitter more and more, Facebook more and more. There are these trolls This is different than the copyright trolls that are lawyers. These are just regular trolls that look for their political adversaries, and they send in bogus strikes. The other thing that's happening is a bunch of film companies and other big institutions have created algorithms to monitor, because this happened to me. I put up a video and I was just curious how it was going. So like on my own little Barnes Law YouTube, real small, just did it to sort of test things out, to preserve things as an archive, and put up one of the shows that the American Countdown podcast show that I do. I just put some of it up on YouTube, and I've got like 4 copyright strike notices. They're not full strike, but I was like, oh, so this is how this is working. And they would be like, hey, it was clearly just algorithmic driven. Because one time I got a strike for a video I never showed. I just talked about it. And I was like, oh, so the algorithm is audio driven. It's not even written driven. They're like, hey, you showed a news episode from Vice. I was like, no, I didn't. I talked about the episode from Vice because I know how Vice reacts to things, to copyright issues. So the background is that that's all fair use. If you're commenting on it, if you're criticizing it, and definitely if you're creating it for a new project, new purpose, which is all of what memes are. Memes are completely taking something and applying them for a new purpose, new policy. They're not stealing from someone else's. They're not stealing the profit from someone else's creation. They're recreating something else, just using their original material. So it's like Picasso. The Picasso's paintings are his own, even if he's borrowing from other images he's seen and witnessed to create his own. So with Carpe Donktum, and in the law, now it hasn't been well enforced by the courts, but in the law, bogus DMCA not takedown orders are grounds for countersuit and are grounds for getting attorney's fees. And I'll be very surprised if they ever go forward with that lawsuit against Carpe Donktum, because it's a bogus lawsuit, in my view, a frivolous lawsuit. The lawyer said a lot of other dumb stuff in there too, which told me the lawyer was not seriously contemplating suit, or really was not that well versed in copyright law. It was my take from it. But what Twitter should know is they know that they are increasingly used. In fact, there's now, I think, a Wikipedia term for it, copy fraud. So that these are bogus copyright strike claims. They're obvious because, in fact, they're trying to expand the legal protection so that it's more and more clear that if you issue in fact, the Ninth Circuit decision made it part of the law that said it's your duty to make sure that fair use is not a defense before you can issue a takedown notice. And if you issue a takedown notice without doing that due diligence, then, and in fact, there was fair use, then you have to pay the other side's attorney's fees because they're tired of the abuse of this. And it's happening regularly, and Carpe Donktum's the latest victim, and Twitter is co-complicit in it by accepting what they know to be completely bogus copyright strikes. Now, I think maybe down the road, Twitter could maybe be sued as a co-conspirator for participating with the benefit of sort of these, now in this case, a smaller operator, but most of the times they're protecting big movie companies and other people like that. Same with YouTube, same with Google. Google's completely protected because their image search is considered not copyright protected. But if someone else uses an image from Google Images, they can be sued. So they've been given all these special protections, and now they're abusing that special protection to go after what they know to be bogus copyright claims. So that's the background of what's taking place. But it's the new area of law that's been weaponized for politicized purposes, and it's being used by non-lawyers and lawyers alike with targeting people that they don't like politically. Because what Carpe Donktum did was complete fair use. It's the classic definition of fair use.
It's the I mean, the one criteria that I tend to discuss over and over again is what effect it has on the original market for the video. And the only argument that I can see in Carpe Donktum, who basically used throughout his meme, he used the entirety of the original video to the point where the video licensing agency would no longer have to license that video to the person who wanted, who made the use of it. So there's that argument that what Carpe Donktum did basically made it meaningless to actually license the video from the agency that's licensing the video. Whereas in this other lawsuit, MXR Plays, these reaction videos where they just play the video and then react, then there's an argument as to whether or not they're doing anything transformative.
But the key there is it's satire. So every satire would be a copyright violation if by the fact that you made something satirical or comedic allowed you to bring a copyright suit. It's just classic fair use. The other aspect was they're trying to claim like privacy for the kids. When you take a video and you put it out in public, there is no privacy. Not only that, if your kids are out in public, there is no privacy protection. You have to have a reasonable expectation of privacy in order to ever bring that kind of claim. And generally, if you're out in public, if you yourself post the video, it's not private.
Well, especially this video is being licensed through, incidentally, the same licensing agency that had the issue with MXR Plays. And from what I understand, I think they took action after the father of one of the kids objected to the political use of it because the father was quite clearly on the opposite spectrum of the political spectrum from what it was being used for. And it reeks of political targeting, because I hear a kid coming downstairs, which makes no sense because it's too late for a kid to be coming downstairs, but there might be a kid coming down. So anyways, on that note, so the way it happens now, he posts the video, the copyright holder or whoever's licensing the video says, we issue the DMCA takedown notice, or do they not even have to do it?
We don't know the full procedure. They don't have to do that, but usually they make a copyright claim. Sometimes it's a full DMCA takedown notice. Sometimes it's just, hey, this is copyright material. They tell Twitter, whoever that. So it was after the president retweeted it that they issued that. And then they later on came up with their later legal threat that they were going to say it was misappropriation without consent or authorization, which is a bogus claim too. And the thing there is, if you don't like it politically, which is the whole point and purpose of the copyright fair use protection, is to allow such political commentary to take place with video materials or other artistic materials that are out there. Simply make your own. I mean, that's the answer. Be creative, and you don't like that politics being used with your kid. Well, use it for your own politics if you want. You can use it for whatever purpose you want. This was a lawfare gone wrong again, and Twitter using its political platform power to target people on the right that are particularly effective. Carpe Donktum is by far the most effective meme maker in the country to basically try to intimidate others from also using memes. I remember 2016, you could go on YouTube and you had the best Trump memes ever. You had some good other memes, but like during the Trump primaries, they even, they would take a Batman movie and they would have Ted Cruz's head on one person and Rubio's head on another. I mean, it was great fun. And it's been ruined by these fake copyright claims, copy fraud claims by big companies in complicity with big tech.
But now, but from the procedural standpoint, though, could Carpe Donktum not file a counter notice to the DMCA takedown notice, and then he would have to be sued within 10 days of having filed the DMCA counter notice?
Yes, and my view of the law, even though they haven't always interpreted it this way, is that he's entitled to bring his own claim for copy fraud. Because that's what took place here.
Yeah, but in the meantime, though, he's still banned. But my understanding, though, was that he would file a counterclaim. Whoever claimed the copyright would have 10 days to sue, and if they didn't sue, then Twitter would have to reinstate the video. Is that an inaccurate understanding?
Twitter wouldn't have to put it back up. So Twitter can still do what they want to do because they can do it regardless of copyright law. So they would no longer have as a basis copyright law as an objection, but Twitter can still remove anything they want anytime they want currently. The law is not limiting them, practically speaking. So copyright law would not compel them to do so, but they wouldn't have the excuse of copyright law, but but Twitter itself can do whatever it wants, whenever it wants right now, pretty much.
And so there would be no claim against Twitter for what claim could exist against Twitter?
My theory is to try to pursue some of these folks on the grounds that it's conspiracy and collusion to engage in copy fraud, kind of like the allegations in the city of Seattle.
Okay, which is a good segue. Now
Yeah.
I hope that enlightens everyone as to the Carpe Donktum. I thought that if Carpe filed a counter notice and they didn't sue, that Twitter would have to put it back up, but it seems that they wouldn't have to. These are sort of terms of service, terms of use, conditions that Carpe Donktum broke one too many rules, even though he, arguably did, and then Twitter came down with the hammer.
And my view is he never broke any rules at all. I think the interpretation of that is it's abusive. Fair use is there to protect creativity. Copyright is there to protect creativity. We should not be punishing creativity under the guise of copyright law enforcement. That's directly contrary to the point, purpose, and actual language and text of copyright law.
And actually, Joe Bowman says, how is it that public officials cannot block a user on Twitter, but Twitter can ban people who are running for public office?
Because technically, when the public official does it, it's a governmental action, it's state action. When Twitter does it, it's not.
Okay. And if maybe you know the answer to this because I've been wondering as well. I know Rolling Stones has been getting mad at Trump for using you can't always get what you want at the end of his rallies. How does that work? I mean,
now music is a little tougher. So a lot of other material, fair use is pretty broad. It's a little trickier when you play music. So you can play a certain amount of the song. Generally, you can license a certain part of the song. Generally, and so it depends on what the situation is. So that can get tricky, and it depends on whether also once it's in the public domain, then you can of course play it however long you want. But that's where it gets a little tricky. My view is that I don't understand. More campaigns should do their own songs. When I used to run political campaigns, I always hired a songwriter, came up with our own campaign song because it's memorable. It's distinctive. It's unique. All of that rather than rely on someone else's song. Even more so in the modern age where it can be tricky to deal with copyright law with music gets a little tougher. It's a little bit harder basically to claim fair use with music.
Okay, amazing. And I'm just marking the time down, 1 hour 30. Let's finish this up on CHOP because there has been a class action suit filed. You sent it to me beforehand. I read through it quickly. I'm going to have to, I mean, this is going to be worthy of a separate video because I like a standalone vlog just because there's a story being told in that lawsuit, which win or lose, this is one of those lawsuits where the people drafting it just wanted to tell their story to the public and they want the public to know what's going on. You want to explain the situation for the people who may not know?
Sure. So I think it was a response to a super chat in our last session. Someone asked about the possibility of bringing a claim. And what I said is I thought that you could try to bring a due process claim, but it's tough because there's no right to protect unless you can show conspiratorial collusion with the city. But I thought they could possibly bring a public nuisance claim. So that's what they brought. They brought a combination of due process and public nuisance claims. So that is consistent with it. And the best thing they have going for them is the idiotic mayor of Seattle constantly bragging about her complicity in what was going on, saying, oh, this is just the summer of love and whatever else nonsense she was pitching. She didn't realize she created liability. Now, all of a sudden, the lawyers had the grounds to say, this is not just a matter of a duty to protect. This is a matter of the city deliberately promoting, colluding, conspiring, aiding, abetting what is taking place here. So what wasn't a substantive due process claim, what was not a procedural due process claim became one because their argument is, hey, the city made a decision to take away our property, but they didn't give us notice or a hearing. And that's a procedural due process claim under the 14th Amendment. In addition, we have certain fundamental liberties to exercise our business. The city decided to strip it from us by promoting this Chaz group. And that will constitute a substantive due process claim. And of course, it's also a public nuisance. But the due process claims allow them to go to federal court and bring it under 42 U.S.C. 1983, which allows for a fee shifting provision. And then they did a great job of detailing the complaint. Some people were irritated that they were politically saying, we don't oppose CHOP, we don't oppose this and that. And Chaz. They're doing that because they're in Seattle, so they know they're going to get a lot of judges from that side of the aisle in all likelihood, and jurors from that side of the aisle. So I wouldn't have taken that path, but they chose to. So c'est la vie on that side of the aisle. But they wanted a broad section of businesses to be part of their class action, and their point was then they go through the great detail of how crazy it has been in that zone, that all of these mainstream media narratives of, oh, this is not a big deal, this is all fine, this is all kosher. You know, people like Will Sommer at the Daily Beast or people like Gerald Holt at the Right Wing Watch, we're trying to pretend this was not a big thing. The Oliver Darcy at CNN was trying to say, you've probably heard this crazy story about a lawless zone in Seattle. Well, that's just a bunch of exaggerated hooey. Well, this lawsuit shows how much they lied in what they put out there. Their information was false and misleading. So I think it exposes the left and the media for trying to cover up just how bad this was, because this lawsuit details it in great detail. And many of the people suing are politically aligned with the left. So that you can't say it's a politically motivated suit, because clearly it's not.
It is amazing because it goes through the general context, but then it goes through each of the, I think it's 4 or 5 stories. It's hell on earth. It's like one thing to have bad neighbors, but it's another thing. One of the petitioners can't get their internet repaired because nobody's going in there to fix their internet. They're talking about how public parks have been turned into effectively like gardening zones, but not
often open sewers.
Open sewers. I was going to say like gardening on the one hand, but people doing their business and feces and everything all over the place. It's hell on earth. And they've
graffiti, property violence. You step outside, you're at risk of personal violence. It's Escape from New York in live time. They just moved it to Seattle.
And there was it's amazing. So they detail the stories. They go into detail about these 5 very, very upsetting stories. I mean, you imagine there's real people there. It's not just words on the paper. Then
many of them vulnerable and elderly.
Yeah, and they get into the due process, but they did bring up 2 interesting claims under the state law. One of them was I don't have it in front of me, but it was a unlawful gift.
Yeah, that part was interesting. I saw, and there's legitimacy on that. That basically all of the claims except nuisance. Though with nuisance, they went after the city, claiming the city was now creating the nuisance, which I thought was a smart claim based on everything depended upon the ability to claim the city was knowingly involved, to be intentionally complicit, to establish liability. But they have the mayor on record, so they're there. They're good to go there.
No, it is amazing. The unlawful gift is basically that they're saying the city gave people who were undeserving. They basically gave something to someone without any lawful reason.
They took my property and gave it to the schmuck over there. And the schmuck over there wasn't entitled to it. They didn't give me any procedural due process while it happened. And by the way, it hasn't turned out well.
It is. I saw on civil losses, you might have to cover the Chaz chop. You have to. I mean, you have to. Everyone should read it. And if I can do nothing more, because I'm not a master of the law as relates to the law, just to summarize it and to highlight the passages that people need to know, because it's the kid's coming back downstairs again. And I think my wife is going to go crazy. It's an amazing story. It's an amazing story, and it's not being told, and it's everything you would fear when the fundamental rules that you've grown accustomed to break down in society. I mean, so you read it. It's interestingly drafted. It's creative. What do you think? How do you think it's going to go? You could obviously to dismiss.
The whole key. Well, they'll get to discovery now, because I think the hard part with always bringing the suit is that there's no duty to protect, and they've limited the terms of substantive due process and procedural due process to make it very hard to sue the city for something going wrong by private actors. But here, because the mayor has been on the record so many times praising and protecting it, she took Trump's bait repeatedly. Trump clearly wanted to debate her to say dumb stuff, and by golly, she did. And so now that it's going to be like the San Jose suit that Harmeet Dillon brought, where those protesters got Trump people got pushed into protesters who violently assaulted them. And normally you can't bring a suit for that, but there they deliberately structured the exit route to make it more likely that they would be physically assaulted. And that's why the suit went forward. And then the mayor had said some dumb stuff a couple of days leading up to it. So here the mayor said far worse. So they have clear evidence of complicity. They'll get to discovery. That's going to be embarrassing because of the internal emails, commentary, and other stuff. There's going to be dumb stuff. There's going to be, my guess, by the police captain's statements. I mean, because the police, she was been very upset about this the whole time, giving up the precinct, was mad about it, was very public about that, was willing to risk public attention related to that African-American woman who was willing to do so. So, there's going to be a lot of police reports and other information that's very embarrassing to the city that shows the city's knowing culpability and complicity. So I think they're going to have to settle and write some big checks.
Which is the ultimate irony, is they're going to write checks from the coffers of the taxpayer dollars. They're not going after anyone personally for this, nor could they, I imagine.
Yeah, they don't know who they are, really. So you could sue like 55 John Does or 200 John Does. There's the one head guy you could sue, the chief warlord of Escape from L.A., Seattle style. For people who don't know, Escape from L.A. and Escape from New York are two great movies by John Carpenter. And A Modern America kind of looks like Escape from New York. But I don't think that would be very profitable. I mean, trying to serve all those people. That's why I always thought it'd be tough. You could bring a nuisance case and try to force the government's action, but the benefit to them is the statements of the mayor are so clear they can allege collusion, complicity, and deliberate indifference, which is the substantive due process requirement. And here, intentional complicity, in fact, in creating a public nuisance because she wanted to, make showboat in front of Trump. And so it's another place where Trump's Twitter has allowed a lawsuit to happen that probably would not have otherwise happened because the mayor took the Trump Twitter bait.
But no chance of going after the elected officials, the mayor, on a personal basis, on the basis that what they're doing so far exceeded their mandate as government officials.
That they've made it impossible to sue for anything that relates to duty to protect. They basically say there's no duty to protect unless the person's effectively in your custody. And so I think they've done too much of that and letting the cities off. It's all based on the myth that the king, that our leaders were appointed by God and thus can do nothing wrong. That's where sovereign immunity comes from. It's a created doctrine by the government and particularly by the courts to cover for their complicit brethren in other departments of government to not face responsibility and accountability for their actions. But it's the law of the land as it currently exists. So your only real ability to go after them is where you can show culpable knowledge that this was intentional and directed by their behavior, that it happened because of what they did. The city's defense here would be basically a causation defense. That, look, this happened. We didn't create it. We didn't really try to protect it or promote it. We actually did try to reduce it. It was just the reality of the situation. And, it's like living in South Chicago any given weekend. There's only so much we can do. That would be their defense. The problem is the mayor said too much, enough to get to discovery, and discovery, my guess, will be even more embarrassing, enough that they'll likely write a check, and the taxpayers will foot the bill for the craziness of this experimental country in the middle of our country.
All right, well, that'll certainly be. They'll vote with their. I guess they'll vote them out if they they'll vote with their dollar, so to speak. Nicholas Rome says, Mr. Barnes logged off before my question could be answered last week. Are we seeing a modern day equivalence of SDS to the Weather Underground organization movement of the 60s and 70s?
Yeah, well, the fact that they had tied a board member to the organization that was connected to BLM, who was part of an even more radical organization, was part of an active actual communist organization that was trying to blow up buildings and other things, also might have been connected to the famous Brinks robbery. The fact that she was connected to all of this and sat on a critical board suggests that it's something even more dangerous than Weather Underground. Weather Underground at least tried to limit their bombings to property, try to avoid killing people. That they did not succeed. But, they were actually less radical than I think some of these groups, definitely less radical than Antifa. And Antifa would take it much further if they could. And I think some of the other groups that are connected to this would take it much further. So it's more like the Shining Path of Bolivia. That would be the movement to look at a little bit. And they don't have the power of the Khmer Rouge, but they have some of the mindset of the Khmer Rouge or Mao's China. It's a much more totalitarian mindset. Weather Underground was more targeted, deeply problematic still, domestic terror organization. But they were much more targeted, and as was the Students for Democratic Society, which these days I can't see Students for Democratic Society without remembering the Big Lebowski, him sitting there smoking pot and saying, no, he wrote the first, the authentic SDS document. The second one was a cop out. So that's all I can think of. But I recognize, but so it's the same mindset, but even more dangerous potentially. Now, most of these people are kids that are involved in this, so their connection to criminal operatives under the criminal element, criminal gangs, is essential to their degree to escalate the violence. And organizing the violence will be more difficult, but they come from the same mentality, except much more dangerous mindset-wise than the Weather Underground.
Okay, amazing. And now, Tony Nieves, I missed the super chat. I thought I brought this one up. It was a joke about Trump. Chances of Trump releasing Area 51 info on his way out the door, maybe his nephew to the system. It's funny. I missed there was some sort of Twitter back and forth between Trump and his kid about Area 51, but I didn't get the full details of that exchange.
I nor did I. It would be great. It wouldn't surprise me to see Trump whenever he's finally leaving office, for him to declassify tons of stuff and just release it to the world. I'm hoping that happens. Like everything connected to the Kennedy assassination, whatever else is out there, just dump it on, give it to everybody. Let the world see what's going on. But whether he does it and whether they let him do it are two separate matters.
Oh, if he decided to do that, is there a recourse to prevent the declassification?
Nothing legally. It would be extra legal remedies.
Okay, let's move on from that right away. Skylar, the creator, says that Raz dude assaulted a man and handed a rifle to a possible minor on camera. Do you think he'll get jail time? Do they know who that person was into like, I'm not trying to, I don't.
Yeah, if it's the guy that there's some very disturbing history of the guy that was identified as the first warlord of the region. I think that's who they're referencing. There's disturbing connections to a wide range of behaviors, films that are deeply problematic, other behaviors that are problematic, potential arms running that's problematic. So I'm sure there's a lot there, but the only people who will probably prosecute that will be the feds. I don't see the city or state doing anything given their attitude and demeanor and disposition to date.
Rico Time says Matthew Christ.
You could definitely. It's going to be tricky. Rico was designed for what it was not designed. People think Rico is designed to go after the mob. Actually, kinda. Rico was designed to deal with when the mob took over a legitimate business. So it wasn't meant to deal with the mob as an organization. It was as what happens when the mob infiltrates a dry cleaning business, a laundry business, a waste management business. Not saying a lot of waste management businesses have mob ties, or that limo driving businesses have mob ties. Just put that out there. For that kind of infiltration. So it wasn't really. I've done civil RICO cases. Got the first major civil RICO case against a law firm in the history of the country done, and got it past summary. Got all the way to trial before finally that case settled. So so RICO law is much harder than it looks. Now they tend to be real liberal with it and interpreting it for criminal purposes, but I think it's going to be tough. Antifa's like not a real organization. It's more of a loosely knit, cells that are connected to, it's organized like Al-Qaeda. It's not very organizational or hierarchical. And so it's meant to be that way. It makes it much more effective. It's more of a shared sense of ideas and shared training methods. And that's really what it is. Less organizational than the Klan even. So I think it would be tough to bring a RICO claim, but not impossible.
Excellent. What do we say? Should we wrap this up?
Sure. If there's any more.
Yeah, we'll give time for some questions. I think we covered everything that was on the table and more. You think the CHOP lawsuit is going to get to discovery unless it settles? The question is going to be, did the plaintiffs bring this as a question of principle where there's going to be no monetary settlement that they will accept or no adequate amount that can compensate them? So actually, the question from my end, they're bringing it as a class action. In the States, what's the difference between a class action and joinder of lawsuits of multiple plaintiffs?
All it is a joinder, except it's a joinder where you don't have to name all the plaintiffs. So if you get a class action certified, it can be for like 10,000 people, and they're never joined formally, but they get to join in the remedy. So they're not necessary. So they're not named parties who are subject to the suit. They are only subject to its remedies if they opt in. Most of them get a chance to opt out. The only other legal action I was thinking of was the state of California. A judge in the state of California did a reverse version of, like, there was the preemption claims. Now there's the claim that the legislature brought that what the governor is doing, I think it's involving the mail-in ballots and masks, whether or not he's usurping his legislative duty through the executive branch in a court in California, one of the smaller counties. They brought the case in the right place. The smaller counties in California are not nearly as to the left in the interior of the state. The state's really two states thrown together these days culturally. Said that, in fact, Governor Newsom did, like Wisconsin, did in fact violate the provisions that the governor's basically acting as a legislature, and he doesn't have that prerogative. So it's good to see that happen. And I know there's more people looking at more lockdown suits as these mask regulations go in, and as they're doing a second round of at least quasi lockdowns. Governor of California today announced a bunch of bars are going to be shut down in a bunch of counties, similar in Texas and maybe in other places too.
Okay, excellent. We got two more super chats here just at the end. If California 209 to remove affirmative action amendment passes, would it go to SCOTUS? Any chance of it actually taking effect if voted in 50.1%?
The attempt to, basically the attempt to make it legal to discriminate against race will not be constitutionally affirmed. So the attempts in California to actually make it so that you could legally discriminate based on race would violate the 14th Amendment. So it will not, their attempts, if someone knows, they can change the law without it becoming a constitutional problem. But once somebody believes that now they can discriminate, that will in fact lead to legal action that the federal Constitution still protects.
Amazing. We got Kelly Graham. Thanks again, gentlemen. Kelly, thank you very much. And Jay Mill. Sorry for the repeat. What would happen to everything Durham related if Trump loses indictments, ongoing investigations, etc.?
It'll go bye-bye, just like Durham's investigation into the CIA spying on Congress went bye-bye. So Durham has a questionable history. He's done some good stuff in the past. He did help clean up Boston related to everything that happened up there involving the famous mobster. But he was very questionable in what he did with the CIA spying on Congress. So we'll see if he does anything and what he did vis-a-vis Guantanamo. So I think we'll and torture and whatnot. So hopefully he does something more here. There's been a lot of big talk so far, little action. Hopefully there will be action, but time will tell.
Okay. And now that I remembered before we end this, I don't remember what state it was in. I think it was Oregon, where they mandated face masks but had a racial exemption.
Yes. So I mean, that's clear. It's a form of discrimination, effectively, and so I think it'll be subject to suit on federal civil rights grounds. The Oregon's sort of been a leader going nuts about a lot of things. So there's the sort of the lockdown related suits. There's the mask or what you could call COVID related suits, whether it's economic lockdowns or speech limitations or access to the ballot or the mask issues. And in some cases, discriminatory application. And then there's the issues related to the riots and the looting, which will the Chaz case is a case that a lot of people will follow because all of these politicians that went along with some of this activity in some of the cities, counties, and states where it occurred now may be subject to suit because of their complicit behavior.
It's amazing. I mean, that story is going to be the next, like, not to look at it in a opportunistic way, but like the Flynn saga was eye-opening in terms of everything that went on with the FBI. This is going to be eye-opening in terms of policy decisions and a government basically letting its people down. It's going to be something to follow.
It's a fascinating era for the intersection of law and politics. I mean, just in 6 months, we've gone through an impeachment that was unprecedented for a first-term president since Andrew Johnson, then a pandemic with a political reaction we've never witnessed in American or Western legal history, the modern era, and then a scale of riots and looting and these separate little zones that we have never experienced at this scale in America. So who knows what's next?
Yes, and we're barely halfway through the year. Mitch Sampson says, thoughts on mail-in voting and faithless electors?
I have some articles on faithless electors. Back at the time, I was pushing back on the attempts to allow that to occur. I think constitutionally it's constrained and constricted. And in the same capacity, I think these criminal prosecutions that are occurring related to fraud involved in mail-in balloting is going to limit the ability for that to happen. The Supreme Court turned down the Texas case where the Democratic Party had sued the governor of Texas demanding he do mail-in balloting. I don't know if the Republican suits against the Democratic governors doing mail-in balloting will succeed, except in California or like circumstances where it has not passed the legislature. That part of the case may succeed. I do think there is an above-average risk of voter fraud involved with mail-in balloting as currently constructed and applied in the states.
Okay, and that gets to Vicky Rose's super chat question as well. All right, Robert, the last time one of us left early, I had bad luck with the audio afterwards, so I'm going to thank everybody for tuning in. By the way, we were at 4,300 people, I think, at the peak, and over 4,000 throughout. This is amazing. I guess people are really getting something out of this, and I'm glad because it's amazing. It's amazing. I get something out of this, Robert. It's information for the world. And when I do transpose it into podcasts, because I'm in the process of just finishing that up, it's going to be even more accessible to anybody who doesn't necessarily have 2 hours to sit down in front of their computer. So
we have to get a copyright permissible version of Viva Las Vegas, except Viva Law Barnes, as background music. That might work.
You know what? I play piano. I'll do an acoustic version myself at home.
Perfect.
All right, everybody. So we're going to tune out. Thank you all for tuning in. We're going to do this maybe, I guess, next week. We'll see what everyone's schedule is. Send me email, send me questions, suggestions, and I get to as many of them as I can. Thank you all for the super chats, and I apologize if we missed them. For all, I've said it before, I'll say it again. Robert and I are splitting these. I still owe you from the last one, Robert. I don't know where we're going to do this, but I'm going to get it to you because this is the new format, and I don't want to feel like I am getting more out of this relationship than Robert is. But I think everybody who is watching is getting something out of this, and that is an understanding of the law and what's going on in the world around them. So with that said, everybody, have a good week and weekend. I guess have a good week. It's Monday tomorrow. And see you soon. I'm checking out, and Robert will say our goodbyes afterwards. See you guys later.